6. I believe that y'all substituted in Senate Bill 258, which was about impersonating an election officer.
Correct, and we removed the original contents of 2056, but I think we probably need to add that back in.
I think they're both good measures.
Yeah.
And so I would hope that you all be amenable to putting back in the contents of 2056 while keeping 258. I'm sorry, yeah, 2056 was about fixing a loophole in the law. So last election, several candidates they were nominated by a third party to run, and they also ran in a major party primary. And what we discovered is because of this loophole, they could have lost their major party primary and still been on the general ballot with the third party. So they basically would have got 2 bites at the apple. And so this bill would close that loophole. So they have to pick right then whether they're going to run with the major party or run with the third party.
Or as an independent.
Okay, gotcha.
Yes.
What's currently in 2056, or are we adding 2056 back?
Yeah, so please, somebody correct me if I'm getting this wrong, but 2056, they replaced the contents with Senate Bill 258, and we are going to we're going to add back in, while keeping the contents of Senate Bill 258, we're going to add back in the contents of 2056.
And so 258 was what? I mean, Senate Bill 258.
258 was, well, Senate Bill 258 was the the state's bill regarding impersonation of an election official. And in the Senate committee, we stripped out the contents of 2056, replaced it with 258. Now what we need to do, and after the fact realize we probably should have just added the contents, we'd like to do that here because that closes that loophole. So it still has the impersonation of an election official in 258 plus closing the loophole about the third party or candidate running as in 2 different parties at once.
And so for just point of clarification, so Senate Bill 258, we did have a bill similar to that, like last year, and it didn't get over the.
Yeah, so this bill was asked for last year by the Secretary of State's office and the Attorney General's office, and I think we passed it and it got vetoed and we weren't able to override, if I'm correct.
There was a Supreme Court case that basically held that the provision of this impersonating an election official was unconstitutional, and that's what this substitute bill is intended to correct.
And in fact, what it did is tighten up the language from the original bill the previous year to just require the intent, as you know, the intent to impersonate. And that conforms, and the litigators of that Supreme Court case felt that conformed with the Supreme Court decision so that we would conform to that.
So, Representative Proctor, Thompson, Mike, so are we talking about the impersonation part? Is that mailers with Secretary of State labels on it, or is it wearing a shirt saying I'm a election person? Clarify.
So and please fill in where I'm screwing this up, but the original statute that was considered unconstitutionally vague by a court didn't have a component of intent. The person had to be intending to deceive. And so this correction, Senate Bill 258, that's been inserted into 2056, would make it clear that the person had to be intending to deceive people as to that they were an election officer.
I can, if you, basically what was added is some language engaging in conduct, including but not limited to using an official seal, whether in signature of the Secretary of State or any county election officer, in any communication with voters with the intent to cause the person to believe that they are somebody they're not.
So thank you, Mr. Chairman. So then does this clear up the concern from the League of Women Voters? You know, how they go and register people to vote?
And, I would not presume to speak for the League of Women Voters, and they would probably not presume to have me speak for them. But their concern with the original statute was that it was so vague that they might be in violation of the law for simply registering voters. And so the purpose of the bill that we ran last year, I think it was a House bill last year that didn't make it past a veto, was to clarify that the people involved had to intend to deceive voters as to their true identity.
And the Supreme Court case involved, I think it was a League of Women Voters versus Schwab. And so the litigators on that case, after they ruled, realized that this new language would conform to the opinion in that Supreme Court case. So whether or not they're happy with it, but that was what the decision was, yes.
Yeah, Mr. Chair, I understand that this is an effort to clean up what the Kansas Supreme Court said, but the language is still extremely vague, and I haven't read or found anything in where the Kansas Supreme Court has reviewed this language and they would be okay with it. So if this stays in as for 2056, it would be problematic. So I would recommend that we pull Senate Bill 258 out, give it another shot, because we haven't even heard it in committee, and see if we can make that better. That would be something I would support.
I will defer to Senator Thompson since he's the guy that inserted this in, but I really like this bill. We did hear it last year, got it all the way to the floor. So unless you have some major consultation with it, I'd like to keep it in.
I would like to keep it in. I think it does address the problem. And even though, yeah, we've tightened up this language. We tried it last year. It's been litigated in court. This conforms to what the Supreme Court decision is, and so I feel like it's important to do. Particularly, we have big elections coming up next year, and so it's very simple. If you don't, we're talking about fraud, and fraud is not protected speech. So, and that was part of the discussion in our committee, is that with the intent to defraud somebody, to make them believe you're an elected official, that you are not protected by the First Amendment in doing that. And I think this bill addresses that, so I think it's very important to keep this in.
Mr. Chairman, before we leave and conclude our conference committee, I have one, pardon the pun, for an elections committee conference, but hanging Chad that's been bouncing around this year that I have not been able to get in another measure that I'm hoping we can consider. So in Kansas statute, the election officers have to test election machines within 5 days of an election. And by that point, they've been early voting for 15 days. So that timeline doesn't make a ton of sense when they've already been using the machines for 15 days, and then they have to do the test in the last 5 days of early voting. So what I'd like to suggest is that we insert a measure, and I think the reviser has a balloon that shows it, but I'd like to insert a measure that changes the timeline so that the machines have to be tested within 30 days of the beginning of early voting rather than within 5 days of the actual election day.
To me, that makes sense, and we'd had a discussion about this, and I've let the rest of my committee weigh in, but here we go.
So thank you, Mr. Chairman. So I agree with this. However, what prompted you to pursue this measure?
The Shawnee County Elections Office, one of the members of the office, not the commissioner, but one of the members of the office contacted me and reminded me that we hadn't done anything with it. But as I've gone around the state talking to election officers, I have repeatedly heard this issue. It's just one of those things that's in statute and it doesn't make a ton of sense. And I think it's this may be the last time the Elections Committee meets in conference, so I wanted to try to get it in this year.
I don't think we have any issues with that on our side. Okay.
Mr. Chairman, you need a agree to disagree?
It sounds like there's some consternation with SB 258 remaining in the conference committee report, so we'll need an agree to disagree, I believe.
I can draft the other conference committee report based on what I've heard here. But you need to run the agree to disagree
Yep.
first.
Yeah, I will. So do we sign before? We sign before, and then I take it to the floor. Is that correct, Mr. Advisor?
Agree to disagree again would be taken up in the Senate.
Aha. But I thought we signed a form in here before he took it to the floor. I thought we signed a form, the 4 people that weren't. I don't think you did last time. Okay, but we do have to sign before he can take it to the floor, correct? Is that true? Yeah, so we probably won't be able to do it at 4 p.m. today unless you get around to all of us in the next hour. Okay. Do you have your running shoes on, Mr. Heim? Okay, yeah, all right, so it may not be today, it may be tomorrow, but yeah, I think we've reached a conclusion, so I'll adjourn the conference committee. Thank you for your patience. I'm sorry we were late.